There is a crack at the Supreme Court. Barely 24 hours after it validated the election of the President Bola Tinubu of the ruling All Progressives Congress APC, a retiring justice of the court, Musa Datijoh Mohammed, who reportedly pulled out from the 7-man panel that dismissed all the appeals that sought to remove President Tinubu from office, has accused the Chief Justice of Nigeria, CJN, Justice Olukayode Ariwola, of abusing the powers of his office. Justice Mohammed, who spent 47 years in active judicial service, bowed out of the Apex Court on Friday, having clocked the 70 years mandatory retirement age. He used the opportunity of valedictory session that was organized in his honor by the Supreme Court to address what he observed as rots in the judiciary that have continued to affect the justice delivery system. He says that on the current composition of the bench of the Apex Court, Justice Mohammed alleged that the refusal to fill the vacant slot of the Southeast on the Apex Court bench was deliberate, blaming it on the absolute powers vested on the office of the CJN. He further stressed that with his retirement, the North Central Zone, which he represented, would no longer have a justice on the Supreme Court bench. On the issue of membership of the panel that heard the presidential election appeals by candidates of the People's Democratic Party, Alhaji Atiku Abubakar and the Labour Party LP Mr. Peter Obi, Justice Mohammed said, to ensure justice and transparency in presidential appeals from the lower court, all geopolitical zones are required to participate in the hearing. It is therefore dangerous for democracy and equity for two entire regions to be left out in the decisions that will affect the generality of Nigerians. Watch and listen to him, and do not forget to subscribe to this channel and also drop your comments while you are at it. Thank you so much for watching.
It was my view that valedictory sessions only provide honorees the platforms to tell their stories and, informed by experience in the course of service, make suggestions as to how to improve the institutions they had served. I was, however, unable to appreciate the extent to which previous suggestions had been exploited to effect the desired reforms. Members of my family and close friends prevailed upon me to reconsider my position. They insisted that it is defeatist to allow failure in utilizing suggestions proffered at previous occasions to deter subsequent contributions. The quest for institutional improvement, particularly in the judiciary, they insisted, must rather be intensified to avoid hastening the demise of our society. A society, they significantly reason, rots too easily when institutional defects are ignored. I capitulated, and thus the unfolding events today. I am also here to say goodbye, particularly to the attendees of today's event, the public, and indeed the country at large, for giving me the privilege and honor of serving the judiciary for 47 years. The valedictory, again, is a thanksgiving exercise for the good health one enjoyed in the course of service. Glory be to the Almighty Allah, the Lord of the universe. Because I would eventually write a book to tell my story, including the experience gathered while serving in the judiciary, it is incumbent for me to be very brief in my address this morning. Appreciable efforts have been made by earlier speakers in telling you who I am. May it please you to hear it from the horse's mouth. I was born and bred in Lima, a ward in Mina, now the capital of Naija State. Then, in 1953, a relatively small and quiet provincial headquarters. I was named after my paternal grandfather, known and called Musa Kumuria. Adamu, my paternal great-grandfather, traded in cattle and kola nuts between Kumuria, a village in present-day Kano State, and Ogbomoso in Oyo State and beyond. He would convey cattle southwards and kola nuts back to the north. They traveled on foot and in groups in those days, making stopovers at Bakani and Durban, both places along the route towards Moka and in between Kontagora and Bida respectively. Musa Kumuria's mother, Hafsatu, was Adamu's third and youngest wife. Before Musa's birth, her elder children had died serially. On conceiving and determined not to lose Musa, Hafsatu insisted that she accompanied her husband on his trade surgeons. At Durban, on one of such occasions, Adamu fell ill and died. Hafsatu, rather than travel back to Kumuria, decided to settle at Durban with young Musa, whom she feared, like his deceased siblings, would also die if they went back home to Kumuria. Hafsatu remarried subsequently and had a daughter, Gogo Saidatu, Kumuria's uterine sister. Not quite long, she lost her second husband. Insistent pressure from Musa's uncles back in Kumuria made her to relocate to Paiko and hence to Mina. Musa, then a young man, joined the labor force engaged in the construction of the rail line passing through the town to Baro, a nearby village, as well as southwards to Lagos. With the successful completion of the construction of the rail line, Musa Kumuria settled in Mina into the grain trade. He married Hadiza, a young Hausa lady from Tawa in the present-day Niger Republic. They were blessed with 3 children. My father, Muhammad Najime, the second male child, was the youngest. Usman and Aisha were his seniors. My maternal grandparents were of the Fulani stock that accompanied the Dattijoh jihadists to the Chief Justice of Nigeria is the chairman of the National Judicial Council, NJC, which oversees both the appointment and discipline of judges. He is equally chair of the Federal Judicial Service Commission, the National Judicial Institute, NJI, the Legal Practitioners Privileges Committee, LPPC, that appoints senior advocates of Nigeria. In my considered opinion, the oversight functions of these bodies should not rest on one individual. A person with absolute powers, it is said, corrupts easily and absolutely. As chair of NJC, FJSC, NJI, and LPPC, appointments as council, board, and committee members are at his pleasure. He neither confers with fellow justices nor seeks their counsel or input on any matter related to these bodies. He has both the final and the only say. The Chief Justice of Nigeria has power to appoint 80% of members of the council and 60% of members of the Federal Judicial Service Commission. The same applies to NGI and LPPC. Such enormous powers are effortlessly abused. I repeat, such enormous powers are effortlessly abused. This needs to change. Continued denial of the existence of this threatening anomaly weakens effective judicial oversight in the country. Now, by the provision of paragraph 20 of Part 1 of the 3rd Schedule to the 1999 Constitution of the Federal Republic of Nigeria as amended, the NJC shall comprise the following members: the Chief Justice of Nigeria, who shall be the chairman; the next most senior Justice of the Supreme Court, who shall be the deputy chairman, Regrettably, the next most senior Justice of the Supreme Court, like deputy governors of states, shorn of any official function except at the pleasure of the governor, is neither consulted on anything nor does he have any official function. His job as number 2 is purely as the CJ and pleases. It is incumbent that the system provides for more inclusion and consultation among the stakeholders. Now I move to the issue of funding and independence of the judiciary. Allusions have been made innumerable times about poor funding and how the judiciary has been emasculated by inadequate funding. My Lord, the late Honorable Justice Mustafa Akambi, former president of the Court of Appeal, in a publication titled "The Main Obstacles of Justice According to Law," said, and I quote, "A good judgment flows from a mind that is not bogged by the thought of, where do I get my next meal? Or where do I get the money to pay my son's school fees? Poor conditions of service disturb the mind. It is an obstacle to clear and positive thinking. Beyond the issue of the salaries of justices remaining static with no graduation for almost 15 years now, it is instructive to inquire what the judiciary also does with its allocations. Who is responsible for the expenditure? An unrelenting searchlight needs to be beamed to unravel how the sums are expended. In 2015, when President Muhammad Buhari became the president, the budgetary allocation to the judiciary was 70 billion naira. In 2018, appropriation bills submitted to the National Assembly, the president allocated 100 billion to the judiciary. The legislature increased it to 110 billion, 10 billion above the 100 billion appropriated for the 2017 fiscal year. At the end of President Buhari's tenure in 2023, judiciary's allocation had increased to 130 billion. 130 billion. This is an increase from 70 billion to 130 billion in 8 years. The present government has allocated an additional sum of 35 billion naira to the judiciary for the current financial year, making the amount of money accessible by the judiciary to 165 billion naira. If one looks at what has been given to the states, each state was given 5 billion to solve its problems brought about by the conditions we are going through because of the fuel thing. If you look at what is given to the judiciary, and yet we are still saying that the judiciary is being emasculated, I think there is something wrong somewhere. More than 80% of the amount appropriated by the 9th Assembly has so far been released to the judiciary. It is envisaged that the additional 35 billion naira will equally be released by the present government. I'm sure it will be released by the present government because I know the antecedents of Mr. President. Because when he was governor in Lagos State, I was privileged to be in the Lagos State Division of the Court of Appeal. And I knew his attitude towards the judiciary. I don't think he would be flippant to say that he's doing this and to recline from doing that. I'm very, very optimistic that that amount of money will be released to the judiciary as well. Now, notwithstanding the phenomenal increases in the sums appropriated and released to the judiciary, justices and officers' welfare and the quality of service of the judiciary rendered have continued to decline. There is a terrible decline in the services and the welfare of justices and officers of the institution. I should know, and I know, and I'm saying it as I know them. It may interest one to know that, and this is another ridiculous thing, that the Chief Registrar of the Supreme Court earns more than the justices of the court. It's not something of today. This anomaly has been in existence all these years. I was a Chief Registrar in 1986. I knew what salary I drew vis-a-vis what the judges of the High Court that I served were taking. Supreme Court is the apex court. And yet, the Chief Registrar of this court earns much more than I do, earns much more than we all do. And nobody talked. Nobody talked. While she earns 1.2 million a month, justices take home 751,000 naira in a month. The Chief Justice, on his part, takes home 400,000 plus. The Chief Justice. The salary of a justice, curiously, drops rather than increases when he gets the added responsibility of being a Chief Justice. That the unjust and embarrassing salary difference between the justices and the Chief Registrar still abides, remains intriguing, to say the least. It is highly intriguing that this anomaly, we all know it, and nobody has taken it a duty to do something about it. Valedictory session after valedictory session, lapses and challenges that should be nipped are stated to no avail. Why the silence and seeming contentment? The process of appointment of judges and the quality of judgments of courts. A couple of years ago, appointment to the bench was strictly on merit, strictly on merit. Sound knowledge of the law, integrity, honor, and hard work distinguished those who were elevated. Lobbying was unheard of. Lobbying to accost justices into their chambers by people who seek to be elevated, that the judges should put in words for them, were unheard of. You will just be sitting, and if those who are given the responsibility of making the elevation find you worthy, you just get a letter to that effect. You wouldn't have gone to anybody to ask for any favors or recognition. But that is not the case today, unfortunately. I never lobbied, not at any stage of my career, to secure any appointment or elevation. And I challenge anybody to contradict this statement of mine. As much as possible, the most qualified men and women were appointed. That can no longer be said about appointments to the bench these days. The judiciary must be uniquely above board. Appointments should not be polluted by political, selfish, and sectional interests. The place of merit, it must be urged, cannot be overemphasized. Now I will move to public perceptions. What perceptions the public has about the judiciary. Public perceptions of the judiciary have over the years become witheringly scornful and monstrously critical. It has been in the public space that court officials and judges are easily bribed by litigants to obviate delays and or obtain favorable judgments. His Lordship Adolfo Okoji JCA, at the point of exiting, had enthused inter alia as follows. Please, I expressed everywhere by the generality of the public. He is one of us. The person making this observation was one of us. He says, please, I express every day by the generality of the public, begging the judiciary to be just, to be truthful, and to save the country from collapse. My question is, whether the judiciary needs to be begged or cajoled. What is it that qualifies any person to bear that exalted name, Honorable Justice? Is it not for him to administer justice without fear or favor? Unfortunately, it has been severely vilified, with the apex court so denigrated and called by a social commentator as a voter gaggle of useless, purchasable judicial bandits. How did the judiciary get to this level? That is the profound question His Lordship was asking as he was exiting. Why is the whole country on edge for fear of what the public regards as unpredictable judicial pronouncements? Like I said, he was one of us. There must be a rethink and a hard reset. If the people we have sworn to defend have lost confidence, there is a problem that must be addressed. Recently, fresh allegations have been made that children and other relatives of serving and retired judges and justices are being appointed into judicial offices at the expense of more qualified candidates lacking in such privilege and backing. It is asserted that the process of appointment to judicial positions are deliberately conducted to give undue advantage to the children, spouses, and mistresses of serving and retired judges and managers of judicial offices. At the Court of Appeal, it is also asserted that presiding justices are now being appointed out of term. When we were there, people to become presiding justices knew themselves and when they would become such officers. But now the perception is that now justices are being appointed out of time. And there is the further issue of the unpredictable nature of recent decisions of the courts as well. A number of respected senior members of the bar inter alia, and I'm glad the president of the Bar Association has also alluded to such comments made by practitioners. Some of these senior members of the bar, inter alia, citing the Ahmed Lawan, the former president of the Senate, and the Imo governorship appeals, claim that decisions of even the apex court have become unpredictable. It is difficult to understand how and where, by these decisions, the judicial pendulum swings. It was not so before they contend. In some quarters, the view is strongly held that filth and intrigues characterize the institution these days. Judges are said to be comfortable in companies they never would have kept in the past. It is being insinuated that some judicial officers even campaign for the politicians. It cannot be more than fine. President Muhammadu Buhari in 2016 ordered the forceful entry into the houses and the arrest of justices, some of whom were serving at the apex court. Not done. In 2019, the government accosted, arrested, and arraigned the incumbent Chief Justice before the Code of Conduct Tribunal for alleged underhand conduct. With his retirement apparently negotiated, he was eventually left off the hook. In 2022, a letter signed by all the justices of the Supreme Court, including the current Chief Justice, the aggrieved protested against the shabby treatment meted to them by the head of court and the Chief Registrar. At the center of the friction was their welfare and the cavalier attitude of the Chief Registrar thereto. In the event, His Lordship Ibrahim Tanko Muhammad disengaged ostensibly on grounds of ill health. Now, it must be said, Chief Femi Falana is right, that the safeguard in our appointment procedures against judicial appointments for improper motive is increasingly being compromised. Certainly, by Rule 8.3 of the Judicial Code of Conduct, any judge who takes advantage of his judicial office for personal gain or for gain by his or her relative or relation abuses the power vested in him. My lords, distinguished invitees, ladies and gentlemen, it is obvious that the judiciary I'm exiting from is far from the one I voluntarily joined and desired to serve and be identified with. The institution has become something else. Then the question is, what do we do? Allow me at this point in time to recall that the 1999 Constitution, as amended, allows each and every one of us the freedom of choosing his religion, the company he keeps, what to say. I am sure we all know where this rights abet and where the rights the very same Constitution grants others take on. I am a Muslim for whose conduct the Quran in chapter 4, Surah An-Nisa, verse 135 provides, O you who believe, stand out firmly for justice. Stand out firmly for justice as witnesses to Allah, even though it be against yourselves, or your parents, or your king. Be he rich or poor, Allah is a better protector to both. So, follow not the lust of your hearts, lest you may avoid justice, and if you distort your evidence, or refuse to give it, or refuse to say it, verily Allah is ever well acquainted with what you do. In Surah Al-Tawbah, verse 71, that particular verse further requires that believers, both men and women, should enjoy what is just and forbid what is evil. And I came across this particular quote, and I read, this is how a society goes down the drain really quickly. First, the society overlooks evil, then it permits evil, then it legalizes evil, then it promotes evil, then it celebrates evil, and then that same society persecutes those that still call evil. Lastly, Adam Grant's words in moments like this are also instructively apposite. And I quote, when you follow a concept, any concept, always consider what would lead you to withdraw your support. If the answer is nothing would make you to withdraw your support, then your integrity is in jeopardy. Your highest loyalty belongs to principles, not concepts. No concept deserves unconditional love. Commitment is earned through character. My contribution towards reforming the judiciary is founded on these foregoing principles. Intrinsic in what I have said today are indices to dampen, nay, eradicate the lapses in the judiciary. The duty to revive the institution remains a collective one. We must persist. It suffices to have, for the purpose of this event this morning, a respite at this point level. Then my conclusions. My gratitude goes first to my Creator for the opportunity, health, and strength of serving through these years. Among those who contributed to the success of my career are, firstly, my maternal grandfather, Muhammad Megari, the Kokondere, my late father, Muhammad Najime, and my mother in that world. I lost the two men not far in between, in 1982 and 1983 respectively. May Allah